This is a part-head appeal in a matter of Granville, so Court is reviewing here and under technology display.
Yes, Mr. Brewster.
My lords, my lady, I was in the course of my submissions on downstream pass-on, and I had started on the law showing the court the two Sainsbury's cases yesterday afternoon. I'm now continuing with the law, and I invite the court please to turn up the Royal Mail and DAF case in the Competition Appeal Tribunal, which the court will find in Authorities tab 19. And the page I want you to start at is 1110. So in this paragraph, the Competition Appeal Tribunal is identifying the issues that it had to decide in the case. And I asked the court to focus on subparagraphs 6 and 7, where you will see that there were two forms of pass-on which the court was considering. The first was a form of resale pass-on. So here the cartel had been a cartel concerning trucks, and one of the pass-on arguments was that the overcharge had been recovered to some extent in the price of used trucks that were sold by Royal Mail and BT. That's the resale pass-on argument. That's distinguished from supply pass-on, where the argument was much more ambitious. The defendants were contending that the claimants mitigated their loss by passing it on to their customers by increases in the prices they charge for their own products, such as postage stamps or line rentals. So you have the downstream product being far more remote from the product on which the overcharge was incurred. And the argument required the cost to operate through a very complicated and large business to arrive at a conclusion that pass-on had occurred. That's important context for considering what the court or the tribunal subsequently says on the law, as we shall see. If I can ask the court next to turn to page 1155. And we've got basic legal principles. And can I just ask the court to read paragraph 176 and 177?
Sorry, which?
So it's page 1155.
1155, sorry. And paragraphs 176 and 7, yes.
The court will see that the legal issues that were explored in relation to proximity were principally thought to be relevant to the supply pass-on case, because that was the case which involved a more ambitious argument on connection between the product on which overcharges incurred and the products on which it was said to be recovered through pass-on. If I can take the court next to the substantive consideration of the legal test for causation, it starts at page 1165, and Mr. Raphael has taken you to some of the passages in this section. I want to show you a few more. And ask the court first, please, to read 207 and 208, which is the tribunal recording why judges have been sceptical about arguments of downstream pass-on. Supply pass-on in this case. And the court will see in 209, the tribunal observes both judges seem to have been of the view that the legal test of causation in this area requires there to be a link between the product bought from the cartelist and the product sold by the purchaser. We agree with that point, but the question is, in light of Sainsbury's, what sort of link there needs to be. The tribunal returns to this question in its conclusions on the legal test for causation. Can I ask you, please, to turn to
Can I
page...
just make sure I've remembered British Westinghouse correctly? Because British Westinghouse is not a pass-on case.
No.
As I recall British Westinghouse, it was breach of a contract for supply of turbines or machines, generators or something like that for use in a business. They weren't up to specification. So the factory owner, the claimant, replaced them with what turned out in fact to be more efficient turbines or machines. And the question was whether the energy savings, I think, which improved the overall profitability of the business, had to be brought into account. Have I remembered that correctly?
I think that's correct, my lord. And
So it was a factual question about whether a benefit in terms of increased profitability from the running of a business using the more efficient generators had to be brought into account when assessing contractual damages.
yes, and this House of Lords stated, or the dictum states, that it needed to arise out of the transaction that was...
And they said it did because, although they didn't go on to decide how much, but it did because had it not been for the breach of contract, the defective nature of the first set of generators, the contractually supplied ones, they would never have bought the better and more efficient ones.
I think that's right, my lord. I need to check again against the facts of British Westinghouse itself. But it was a contractual damages claim, and the question was whether the benefit from better...
Right, so the causal connection, just looking at paragraph 210,
210.
which the Supreme Court relied on, apparently, in Sainsbury's, they were making those, the British Westinghouse wording, which they adopted or used, was arising out of the transaction. The causal link was a sort of almost a but-for type test. But
yes.
You could see in British Westinghouse the very direct correlation between a decision leading to a profit, a better profitable business, and the breach that was being sued. Yeah. Right.
My lord, if we turn to the conclusion on the legal test for causation, page 1169. And I invite the court to read, please, paragraphs 224 and 225, where the tribunal addresses the resale pass-on case. In the resale pass-on context, which I'm going to be submitting is much closer to the facts of our case here, no one seems to be doubting that proximity is established and can be established by the close relationship between the product on which the overcharge is incurred and the product which are sold to downstream customers. And the tribunal at the conclusion...
Well, it's not a sale to downstream customers. It's a sale just of the truck which you bought at a higher price because of the overcharge into a market where the used prices were higher because new vehicles started with higher prices. It's not a customer.
That's correct, my lord. But the test that's specified, or the tribunal's observation, is that proximity can, in general, be established by the close relationship between the products in question. So the product on which an overcharge...
It's the same product.
Yes.
It's the same thing. It's just that the used market prices are higher because the new prices are higher, as I understand that case.
Yes, my lord. The tribunal summarises the legal test for causation at 228. And this summary is in general terms. By way of summary, legal test for causation in relation to a pass-on form of mitigation defence. And it sets out what's required. It's not enough for the DAF to say that all costs, including increases in costs, are fed into the claimants and their regulators' business planning and budgetary process. There must be something more specific than that, and there are a number of potentially relevant factors that it can rely upon. And the third one is the relationship or association between what the overcharge is incurred on and the product prices have been increased. In 229, this is not an exhaustive list of factors, but they do seem to us to be the most relevant ones to this case. And if we turn finally to 1242, and paragraphs 572 to 573, where the tribunal is dealing with the supply pass-on case and whether the legal test for causation is met. You see in 572, nor is there any direct association between truck costs and products sold by the claimants. And the observation in 573 about tracing through is in the context of this more ambitious supply pass-on case, where you have a huge business. And the idea is that an increase in the cost of trucks is reflected in the increase in the cost of a stamp or a line rental. But the tribunal makes clear that even if that could be done, the absence of the four factors means that the overcharge is too remote from downstream pass-on prices. Whilst the four factors are not themselves decisive or necessary, we think that in a situation where none are present, the evidence of factual causation needs to be that much stronger so that the requisite proximity can be established. And that's what the Court of Appeal subsequently approves in its judgment. Those are the cases on downstream pass-on. I'm going to turn next, if I may, to our points on proximity and why a direct and proximate causal link exists in this case. Section 2 of my submission on downstream pass-on. We rely firstly on the relationship or association between what the overcharge is incurred on and the product whose prices have increased. The present case is very different from ambitious cases of supply pass-on, where the courts have doubted proximity. Here, the infringement affects the prices of LCD panels of various sizes. But what the claimants are buying in the main, how they incur the overcharge, is through LCD products, so LCD monitors, LCD notebooks. And what they're selling on to their customers are PC packages containing the same LCD monitors or notebook packages containing the same notebooks. So in our situation, it's either the very same product that's being sold on, or the product that is bought is directly incorporated into the product which is sold on. So in the small number of cases where LCD panels are being bought and monitors being put together by the claimants themselves, there's direct incorporation. My second reason is that if the judge was entitled to reach the factual conclusions he did about how the claimants were approaching their pricing, then proximity necessarily follows. His view, based on considering all of the evidence, was that the claimants were likely to respond to increases in the costs of monitors or notebooks by passing on at least some of the increase in the prices they charged for their own products. Now, if he's right about that, as a matter of fact, and I'll be coming on to dealing with that, then it's hard to see why in this case proximity is not established. Now,
Mr. Raphael makes a certain amount of the point that the judge doesn't use the language of direct and proximate link. Presumably all these cases were cited to him, were they? So one would think he would have had them in mind, but it's a bit puzzling, I suppose, that he doesn't have a little paragraph saying this is the test. Or maybe it was so obvious, I don't know.
I have 3 points on that issue. So, first point is that the requirement of proximate causation was not in dispute before the judge by the time we got to closing. I'll just give you some references for that. So it's our written closings at paragraph 204, which is supplementary bundle, tab 47, page 1638. And our oral closings at the supplementary bundle, tab 45, page 1599. The focus of the debate by the end of the trial was on whether downstream pass-on was established on the balance of probability for the evidential question. The second point I make is the one that my Lord Justice Mayles makes to me, which is that in this sort of case, proximity was straightforward if one resolved the evidential question. And the third point is that if there was a technical error by failing to include a paragraph in the judgment specifically stating that the judge had found a direct and proximal causal link, then I have a respondent's notice point, the fourth respondent's notice point, which seeks to correct that technical error. And just for your reference, it's 4 bundle, tab 5, page 280. So we say the real issue in relation to downstream pass-on is just whether the judge was entitled to come to the factual conclusions that he did, that the loss, that at least some of the loss would have been avoided. And that's the issue to which I turn next on downstream pass-on, the facts and the assessment of the facts.
Are you going to cover the point Mr. Raphael made that there's some restriction on the type of evidence that the judge can take into account when, as you said, if the test is, were the claimants likely to respond to the price increases by increasing their own prices? I think Mr. Raphael says, well, you can't answer that as a judge, at least not in the first instance, by just broad assertion of economic theory. Is that a point you're going to come to?
That is certainly a point I will come to. So the starting point for understanding how the judge deals with the factual assessment of downstream pass-on is to recognise the limitations which he faced in this case. I've set out in my skeleton at paragraphs 38 to 41, which is core bundle 14, pages 300 to 304, a summary of the evidence that was available to the judge at the trial. And everyone acknowledges that it was limited. I'm just going to turn it up, my lords. Yes. But the real question, in light of Sainsbury's and the Supreme Court, is about evidence concerning how the claimants dealt with the recovery of their incurred costs in their business. And in relation to that, the evidence that was available was limited. That is no doubt due to the fact that the claimants had been in insolvency for almost 20 years. So the judge did not have the benefit of testimony from witnesses within the claimants who could speak to how they sought to deal with recovery of incurred costs. Neither was there available to the judge a complete data set that would enable experts to perform some sort of quantitative analysis to identify the passing on of incurred costs. But what the judge did have available were 3 tools. The first is documentary evidence concerning how the claimants were pricing their product packages. And these are set out, the relevant documents are summarised in paragraph 40 of my skeleton. Various price generators, bills of materials documents to which the judge refers. And secondly, he has the assistance of expert evidence. So Mr. Parker, for my clients, gave evidence that was not only based on economic theory, but also considered both the relevant market and market circumstances, as well as the documentary material that was available. The appellant's experts also gave evidence on this issue. And as we understood their position at trial, neither was contending that there would be zero downstream pass-on in this case, as a matter of fact. The third tool that was available to the judge was the judge's ability in making any finding of fact to draw reasonable inferences from the information that is available. A combination of the available expert evidence and the available documentary evidence in light of his judgment as to inherent probabilities. And that's the material he had available, and he just had to form his best view on the balance of probability as to what would happen in this sort of case. And the criticisms that are made of the judge should be seen in that context. I turn then to deal with the individual criticisms that are made. And I'll start, if I may, with the point that Lord Justice Snowden was putting to me about the reliance on economic theory. So the first point is that the judge obviously does not rely solely on economic theory. His conclusions are also clearly based on the documentary evidence available and the inferences he's able to draw from the documents concerning the claimant's approach to pricing. Secondly, the judge was entitled to take account of economic opinion evidence in reaching his conclusions as to downstream pass-on. Economic opinion evidence can be used to prove downstream pass-on in combination with other material. I showed the court two cases yesterday. Sainsbury's in the Court of Appeal at paragraph 332, which, just for your reference, is Authorities tab 10, page 776, where the Court of Appeal recognised that economic opinion evidence was relevant. And similarly, Sainsbury's in the Supreme Court, paragraph 178, which for your note is Authorities tab 13, page 940. The Supreme Court approved the Court of Appeal's approach and stated it is clear that the Court of Appeal was not excluding any form of evidence as relevant to the establishment of pass-on. So just because it's economic opinion evidence doesn't mean that you set it aside. The third point is to distinguish the particular type of economic evidence that the judge had before him from the type of evidence that has been criticised in some other cases. So Mr. Raphael took you to the Royal Mail and DAF amendments case, where observations were made about broad economic theory or broad theories of a business simply seeking to recover its costs in the prices it's charged. The present case didn't rely upon that type of broad economic theory as a means of proving downstream pass-on. The economic evidence which the judge heard was grounded in the facts concerning the particular features of the market in which the claimants operated, and taking account of the functioning of their specific businesses as illustrated by the available documents. And just for your note, in the judgment, the judge considers the market aspects of Mr. Parker's evidence at 192 to 6, which is core bundle 5, pages 116 to 7. And he considers Mr. Parker's analysis of the claimant's business based on the documents at paragraph 197 and 198, and notes at 199 that Mr. Parker relied on a combination of features in his opinion evidence. So this is not a case where we've just got a broad economic theory that is being used to try and prove downstream pass-on. Economic opinion evidence was relevant and material for the judge, and he needed to rely upon it in order to inform his analysis. But it's not the sole basis upon which he reaches his conclusion.
I mean, there are some passages in those paragraphs that you've just mentioned which might or might not suggest the judge was, but which are ambiguous as to how much reliance the judge was placing on economic theory. For example, 194, in relation to the second of those points, the role of LCDs as inputs to downstream, Mr. Parker makes 2 points, each of which he maintains support the proposition of a high degree of downstream pass-on. Both are based on the proposition that as a matter of economic theory, pass-on is more likely to occur where a cartel effect, etc., etc., etc. You know, how is that just economic theory, or is that economic theory as applied to this particular market?
It's applied to this particular market. He goes on in 195 to address Mr. Parker's evidence in relation to the UK PC market.
But again, Mr. Parker's evidence was that as a matter of economic theory, markets, he seems to be talking in entirely general terms there.
No, he goes on to talk about product differentiation in this particular market.
Right.
So monitors, in relation to monitors, he makes a point that desktop products offered for sale do not identify the monitor being offered other than generically, and that claimants purchase screens from numerous other different manufacturers during the cartel period. So when the judge is referring to Mr. Parker's evidence as a matter of economic theory, he's referring to the economic proposition that Mr. Parker uses in his evidence, but which is applied to the facts of a particular case. I don't understand the authorities to say that this is a type of evidence that the judge can't consider in determining an issue of fact or rely upon in deciding an issue of fact in relation to whether these claimants would have avoided the loss they suffered as a result of the overcharge. It's entirely permissible. I accept that one would normally need further factual support in order to make good a case on the balance of probabilities. But the judge in my submission was entitled to rely on opinion evidence in combination with the documents he had available to reach a conclusion on the balance of probabilities.
So it's one way of looking at it that if you're pleading as a defendant pass on, you can't just put a broad plea of general economic theory to suggest that there must have been pass on. You need to be more specific to overcome the initial evidential burden of being able to get that point in front of the trial judge. But once you're over the basic, economic theory can form part of the judge's overall analysis of the evidence. Is that it? Or something like it?
Yes, my lord. In my submission, there's nothing wrong with reliance on economic theory. Economic theory here, I think in the sense that Mr. Raphael uses it, is economic theory at a level of abstraction unconnected with facts. Mr. Parker's opinion evidence at the trial was not at a level of abstraction unconnected with the facts. He set out economic principles about how he would expect a business to operate and deal with its costs and its prices. But his views about downstream pass-on in this case involved an application of those principles to the facts of the case.
So is it your position then that the kind of economic theory which is criticised in the cases is at the level of such propositions as a business will seek to recover its costs, and you are differentiating between that from propositions such as pass-on is more likely to occur where a cartel affects the variable costs, or where there is little or no product differentiation, and you say that that kind of, or assistance from that kind of economic theory is acceptable.
Yeah, I do, my lord, and it's in combination with documents which enable the judge to test the economic theory against the facts of the particular case.
Can I just raise with you, there was a passage between my Lord Justice Snowden and Mr. Raphael at the end of day one, where more or less this point was in play, and there was a discussion about the different role of getting your factual basis for the purposes of pleading and then relying on economic theory. And Lord Justice Snowden said the economic theory alone does not discharge the evidential burden, but once you have something in play, the finder of fact could rely on the discharge of the legal burden, and the game is on for everybody. And Mr. Raphael, I think, highlighted the point at which he really diverges. He says the point is it is for them to discharge the burden at all points, and they cannot do so simply by economic theory. If they have a combination of factual evidence, that proves their case to the correct standard. With some economic theory, that may prove downstream pass-on. So it seemed to me that Mr. Raphael says that you have to have the factual evidence establishing essentially the direct and proximate in and of itself, and the economic theory is only really an add-on. And you may have a couple of answers to that. One of which is that that's treating all economic theory as being at a high level of abstraction, which is the point that we've just been discussing. You may have other things you want to say to that, but
In my submission, it's also, when this is put in context, it's artificial. In the context of a trial where downstream pass-on is clearly in play, there's no application to strike out the pleadings on the grounds that there isn't a sufficient basis for downstream pass-on to be raised as an issue in the proceedings. The task for the trial judge is just to reach a view on the balance of probability in light of all of the evidence that's available to him, and attach such weight as he considers appropriate to the evidence that's before him. And that's here, it's a combination of economic opinion evidence, which I submit is not of the broad or abstracted general type, which the cases are criticised in the context of pleadings, but also with documents that focus specifically on the claimants pricing their packages. And the judge is using the two in combination. In my submission, the law can't, it's difficult to see the law striking a dividing line between one type of evidence and the other in a judge's overall assessment of a factual question. So the judge is deciding, was loss avoided by these claimants? Incurred an overcharge through what they bought, was loss avoided? And in my submission, there should be no, there's not an in-principle reason why one sort of divides between categories of evidence.
particularly, you say, in circumstances where these cases, there is a wide variety in the nature and specificity of the evidence that you have, and the nature of the pass-on that is alleged as to the proximity point that we were discussing earlier.
Indeed. So those are my points on economic theory. I was next going to turn to psychological pricing.
Well, before you do that, I mean, one problem may be that some of the documents, like price generator documents, don't seem to enable the judge to draw very firm conclusions. So he looks at them, but one thing he says is, well, I'm not satisfied that they actually evidence sales at the prices generated. And, they only applied to a limited amount of the kind of markets that were being sold into. So I can see the point that if you've got some evidence which support, as it were, positively supports downstream pass on, then economic theory can come galloping over the hill to take you the rest of the way that you need to go. But what's the position when the factual evidence or documents are more equivocal?
In my submission, in this case, the judge is able to reach conclusions about the claimant's pricing processes based on the documents that he's looked at. He acknowledges that the bills of materials documents and the price generators don't, in and of themselves, tell him exactly how pricing was taking place. And there are various statements in the judgment where he acknowledges that either the sales price in those documents could be stated first, or the claimants look at their costs and then check the margin and set a sales price in consequence. But he reaches an overall view as to what's more likely in the circumstances of the case, taking into account all the background factors and background evidence that he has available, which includes evidence concerning the market, my lord, where he has regard to the nature of the costs being incurred, the competitiveness of the market in which the claimants are operating, to help inform his judgment about what's more likely. But this is a case where the judge had limited assistance available to him in terms of direct factual evidence. But we say he was still in a position where he was entitled to reach the factual conclusions that he did. If I turn then to psychological pricing. In our submission, the claimant case on psychological pricing is really a challenge to the weight the judge attached to psychological pricing in his assessment of whether some downstream pass-on occurred. The reasons he gave for his view that the effect of psychological pricing would be relatively limited were all rational reasons he was entitled to give. Paragraph 231 of his judgment, which is page 132 of the core bundle. So he notes, he accepts that psychological pricing may have an impact on the timing or degree to which an industry-wide variable price increase is passed on. But he decides that the issue is highly fact-sensitive and is of relatively limited impact in the circumstances of this case. And he gives his reasons. Firstly, he notes that psychological pricing was not used universally by the claimant. Now, in a context where the argument is downstream pass-on established at all, to any extent, that reason is a sufficient reason in answer to the objection taken on the basis of psychological pricing. But he goes on, secondly, to note additional relevant features of the way in which the claimants were adopting their pricing process, which limited the effect of psychological pricing. And this is their approach to product specification and setting prices in that context. Now on that, when Mr. Raphael was making his submissions, I understand him to have taken objection to that part of the judge's reasoning on the basis that it involves an acceptance of some different form of pass-on, which is impermissible. Pass-on by cost reduction. That's not right in our submission. Pass-on by cost reduction is a form of mitigation that means a business will respond to an increase in its costs by negotiating with its suppliers to reduce its other costs. And the judge doesn't find that that's what's happening here. What's happening here is package specification. So pass-on either occurs by the business increasing the price of an existing package it's offering. You may have a PC package that's already on the market, already advertised, where you could increase its price. Or by setting the price for a new package that's offered. And the judge notes in his judgment at paragraph 236, that if anything, the frequent changes to product bundles provided a recurring opportunity for passing on such costs without incurring the cost of changing prices by adjusting the content of the bundles and pricing them, if thought necessary, using psychologically selected prices for the new bundle. So he's just making the simple factual point that this business, as you'd expect in the IT sector, new PC packages and new notebook packages are being offered routinely. And that gives the opportunity to the business to pass on any increase in the cost of an LCD monitor or a notebook in the prices it charges for a new package.
Can you be, I mean, just so I've understood what you just said factually, is it something along the lines of if the price of the screen goes up, the LCD screen, which is what we're talking about here, it's the component of the monitor or the laptop, notebook, that is the screen, which you can't change as such.
Yes.
I mean, it just can't. What you do instead is you keep the price the same, but you offer the machine with less RAM or something.
You could do that, my lord.
I mean, is that the sort of thing, you just change one of the other components that's a little less visible?
Or part of the package. Sometimes, so some of these packages offer, in addition to the main unit, a printer or whatever it might be, accessories that form part of the package. And you can swap out in that way, my lord.
Or you don't put a cable in with the monitor.
There are many ways of doing it, and the judges just simply observe.
That's what we're talking about there. When you're talking about, in order to keep the price at a psychologically acceptable number, you just offer slightly less. It's like, biscuits are getting smaller these days for the same price. It's that sort of tactic.
Yes. Yeah. And that's it. And I just make the point to distinguish that from a pass-on by cost reduction argument, which is no part of the judge's reasoning and wasn't part of our argument. If I turn then to profitable warranties. And again, in my submission, the claimant's criticism of the judge's conclusion that there was at least some downstream pass-on in this case is based on a challenge to the weight he gives to the effect of profitable warranties. But he was entitled to take the view that the sale of profitable warranties in combination with packages would have limited effect on the claimant's ability to pass on. I'm going to start, if I may, by showing you a passage in the transcript where the judge was putting some points on this issue. So it's supplementary bundle tab 44, page 15.
It's more the effect on their desire to pass on rather than their ability to do so, isn't it? Because the argument, I think, is that they wouldn't want to pass it on because that would jeopardise some of their very profitable warranty sales.
That's correct, my lords. So they would want to, in thinking about whether they should increase the price of a particular package, they would be, the argument would be, they would be concerned that making that increase might lead to the loss of a profitable warranty that would otherwise be sold alongside the product. And the judge addresses this point, he puts some points on this issue. If I can ask the court to turn up tab 44 of the supplementary bundle, page 158A. This is closing submissions, and the judge is putting some points to Mr. Raphael in wrestling with this issue. And can I ask the court, please, to read page 123 of the transcript, which is sort of top right, at line 3, to page 124 at line 5. The judge was concerned in argument that there would need to be some relatively sophisticated thinking if, in relation to individual cost increases, the claimants were deciding whether or not to incorporate those into their prices by reason of a concern about the impact on the sale of profitable warranties. And that he didn't get the impression from the evidence that that was happening in practice. And he returns to this point in his judgment. So in his judgment, at paragraph 237, this is core bundle, page 133. Final sentence in the paragraph. Indeed, the oral evidence cross-examination from Mr. Augustine on this topic shows the speculative nature of the point being considered. He sets out what Mr. Augustine says. And 238, he draws his conclusion from it. The judge's view on this issue, which is one he's entitled to take, is that if what's being said is that the claimants want to avoid losing sales of packages because a number of the sales of packages will come with a profitable warranty in addition, that the real impediment there is one that's imposed by the consumer reaction to psychological pricing. So in his view, based on the arguments that were before him, the issue that might cause a person not to purchase a particular package that was on sale in light of a cost increase would be whether that package might be priced at a non-psychological price. So he's considering the issue. He doesn't see any evidence of pricing individual packages and the profit from warranties being balanced in practice. And in those circumstances, he considers that the issue resolves ultimately into a question of, well, what is the concern that claimants have about this particular price increase so far as concerns their customers? Will they be pricing at a level that's likely to put the customer off?
Well, isn't it perhaps at a simpler level, what he is saying is that due to the passage of time, there is no actual evidence that this was a factor in the claimant's thinking, that as a matter of economic theory, I think it's Mr. Raphael relying now on some economic theory, but as a matter of economic theory, it may have been a factor because the extended warranty sales were very profitable. It's quite a complicated sum that might be needed to be done to tell you exactly what to do. And it's a factor, therefore, that he will take into account and give some weight, but only limited weight. And you say, well, that's a decision for him to make. I mean, isn't that his reasoning, right or wrong?
Indeed, my lord. And he does give the factor weight. He doesn't ignore it. He considers it. And the amount of weight to be afforded to the factor is a matter for him, in my submission. So that's profitable warranties. The next point that is taken is that the variation in profit margins on the claimant's packages meant that downstream pass-on could not be established in this case. And my response to this is similar. Firstly, the judge is aware of the variation in profit margins and takes it into account. And secondly, he just reaches a balanced view on the consequences of the variation in profit margins. So in his judgment, at paragraph 225, he relies on the variation in profit margin as a reason for concluding that there was unlikely to have been 100% pass on. However, he reaches the view, nevertheless, in his judgment, paragraph 242, that there would have been substantial pass on in some cases, but less so in others. So the variation in profit margins on particular packages is not in itself an answer to the judge's point. The judge is accepting that in some cases, pass-on might not occur, but his view is that substantial pass-on would occur in at least some other cases. So it's not a factor that he's ignored, he's taken it into account, he just didn't consider that it was dispositive. Next, pricing on a cost-plus basis. So Mr. Raphael submitted that the fact that the claimants were not pricing on a pure cost-plus basis meant that downstream pass-on could not be established in this case. In our submission, that's incorrect. So a pure cost plus basis of pricing means always pricing at a fixed margin above your cost. And that type of cost plus pricing will clearly be sufficient to prove downstream pass on as a matter of fact, but it's not necessary to do so. Pass on can occur without such a mechanical approach. Where the claimants choose, in some cases, to pass on an increased cost, but decline to do so in others. And again, this is a point that the judge has well in mind. He notes in his judgment at paragraph 197 in the final sentence that if the claimants were pricing in that type of mechanical way, it might result in actually more than 100% of the cost increase being passed on. Because you'd get the margin on the cost increase on top. But none of this is an answer to the judge's factual conclusion that there was at least some pass on in this case. The final point, my lord, is the emphasis on the overcharge being small in this case. In relation to this, the first point I make is that the cases do not establish that an overcharge of a particular size is necessary in order to prove pass on. For your reference, you get that from Royal Mail and Daff in the Tribunal, Authorities, tab 19, page 1073, and the relevant passage is at paragraphs 221 and 222, which is page 1169 of the bundle. Neither knowledge nor size of a particular size are necessary requirements to prove causation. Secondly, the judge is aware of the relevance of the size of the overcharge to the argument on downstream pass on. He notes the relevance of size in two passages in the judgment. Firstly, in the judgment at paragraph 207, and more clearly in the judgment at paragraph 241, where he states, I accept that the lower the price increases as a proportion of the total cost of the products being offered to the consumer retail market, the more likely that an attempt will be made to limit or delay passing on the full effect. So he has the point in mind that the lower the price increase, the more likely it was that an attempt would be made to limit or delay passing on the full effects. But he reaches the view, based on the evidence as a whole, and in particular his view on the tight margins within which the claimant's business were operating, that at least some pass on would occur. And in my submission, that is a view he was entitled to take on the evidence before him. So overall, in my submission, ground 3 should be dismissed. There's no problem of proximity in this case, and the judge was entitled, on the basis of all the evidence he heard, to conclude as a matter of fact that there would be at least some pass-on in this case. And I note finally, in his judgment at 243, he observes, this is Core Bundle 5, page 136, that based on his review of the evidence, the idea that the claimants would have passed on none of the overcharge at all appeared to him to be unreal. I'm going to turn then, if I may, to ground 1.
Are you, under that heading, going to deal with how it is that the judge, having arrived at somewhere between 50 and 100%, although 100% seems rather unlikely if he was indeed taking all of these factors into account, then plumped for 65%?
My lord, yes, I can deal with that under ground 1.
Okay.
Because it is an exercise of broad acts, ultimately, is how the judge arrives at his overall estimate. So, my lord, in dealing with ground 1, I'm going to take my submissions in 3 stages. The first is to take the court to the parts of the judgment in relation to overcharge and downstream pass-on, on which the appellants rely as including potential misdirections of law, and make my submissions on those parts of the judgment. Secondly, to address the effect of the judge's reconsideration of his conclusions. And thirdly, to address the materiality of any error. So, in relation to overcharge, I understood the appellants to rely in particular on the following 4 paragraphs of the judgment. Paragraphs 84, 107, 132, and 143, which is the ultimate summary. We start with 84, which is at page 82 of the core bundle, tab 5. So here, in the second sentence, we just have a general reference to the principles referred to in paragraph 28 above. There's no specific reference there made by the judge to the principle to which a particular objection is taken, namely the principle of erring on the side of undercompensation. And it's part of the section of his judgment where he's just rejected Dr. van der Laan's primary model and it's going on to address Mr. Parker's model. He's not making a quantitative evaluation at that stage.
As I understand it, the point is that you accept that the broad brush is required because of uncertainty, or caution is required because of uncertainty, but it's the rider that says you don't err on the side of caution. That's what we're looking at here. I mean, although it refers to the principles in paragraph 28 above without limitation, he does say that's largely for the purpose of addressing the problem created by the existence of a range of uncertainty.
Exactly.
And reduce the uncertainty. I mean, for itself, I mean, is that objectionable?
It can't be, my lord. The broad axe arises on the hypothesis of uncertainty, so that's where you wield it. So he's just registering there, but you may not be able to arrive at a precise answer. And all he's acknowledging in my submission is that the use of a broad brush or the broad axe may be necessary. There's no error of law disclosed in paragraph 84 itself. As to 107, which is at page 90 of Core Bundle tab 5. So again, it's in the final line of the paragraph. We just have a similar reference to the application of the principle summarized at paragraph 28. And the judge notes, I return to that issue below. And he returns to this issue at 143, which I'm going to take you to. This is in the context of considering the alternative demand variable. So semiconductor billings or GDP growth or business confidence. And he's decided that he prefers Mr. Parker's evidence, but he recognizes that there is a risk to a limited extent that the semiconductor proxy may underestimate the amount of the overcharge by virtue of a limited endogenous element.
He's not at this stage applying the principles in paragraph 28. He's simply saying that using the semiconductor billing proxy is what he is going to do to reduce the area of uncertainty, but he recognises that it's not perfect, and he's going to tell us later how he's going to deal with that point.
Exactly so, my lord. And again, that on its own doesn't disclose any error of law. (132) Mr. Raphael relied on, and as I understood his submission, so this is page 98, forgive me, 98 of the Core Bundle, tab 5. He placed emphasis on the word safely in the first sentence of paragraph 132. Well, that sentence is not addressing the broad axe or the principles in paragraph 28. It's simply addressing inferences that can be drawn from statistical evidence. And he goes on to explain what he's dealing with there, because he addresses the fact that it's not good enough in a case of this sort to rely on a common assumption. There's nothing in paragraph 132 and the use of language there that connects directly to the principles in 28 or discloses any error in my submission. Finally, paragraph 143. And this is the judge's conclusion. It's at page 102 of the bundle. And here we see, in the first sentence in 143, the judge is applying principles summarized in paragraph 28. So this is where we know he's actually coming to apply those principles. And he's taking account of the particular features that he spotted with the modeling. So the semiconductor proxy as a demand variable and post-cartel price persistence. And he notes that if he was to purely adopt Mr. Parker's figure, that would lead to an underestimate of the degree of the level pass on. The next sentence is crucial, my lords, my lady. In my view, a modest adjustment upwards of Mr. Parker's figures is required to eliminate the possibility of under-recovery. Now, in that, what the judge is saying there is that he is taking an approach that will eliminate the possibility of under-recovery. So he's not erring on the side of undercompensation here. He has well in mind the need to eliminate under-recovery. And it's in that context that his subsequent reference in the sentence to the need to be cautious to avoid overcompensation should be understood.
But he limits the upward adjustment in order to be cautious to avoid overcompensation. I think that's the main thrust of Mr. Raphael's objection to this. I mean, if he'd have stopped the sentence to say a modest upward adjustment is required to eliminate the possibility of under-recovery by reference to the sources of uncertainty, that would have been unobjectionable, I think Mr. Raphael says, but it's the next bit where he puts a limiter on the uplift by reference to factors that, the ASDA factors.
So in my submission, avoiding overcompensation is not inconsistent with any legal principle. So the cases state a judge has got to try and arrive at the right amount of compensation, avoiding undercompensation and overcompensation. So his reference to the need to be cautious to avoid overcompensation doesn't disclose any error of principle. He's recognised both. So he's not going to permit under-recovery, but similarly, he wants to avoid over-recovery. In my submission on close analysis, paragraph 143, which is the conclusion on overcharge, doesn't demonstrate that the judge, in applying the principles in paragraph 28, has acted under any misdirection of law. It is consistent with the law.
Well, that might be all very well if paragraph 143 stood on its own, but it has to be read in the light of paragraph 28, which expressly contains the ASDA proposition. Isn't that a fair reading of this paragraph, particularly as it begins with applying the principles summarised in paragraph 28 above?
But he explains in the paragraph in my submission how those principles are being applied in 143. So there's a general reference to the principles in paragraph 128, but in 143 he's unpacking how that's being applied in relation to the overcharge. And he's saying, in my view, a modest adjustment upwards of Mr. Parker's figures is required to eliminate the possibility of under-recovery by reference to these sources of uncertainty, but limited so as to take account of what I consider to be the modest effect of both factors, that's substantive, and the need to be cautious to avoid overcompensation. So in his conclusion here, he's looking at both sides of the equation. And merely the fact that in paragraph 28, he included a statement that was erroneous, doesn't give grounds to challenge his ultimate conclusion of overcharge in this paragraph.
Right, well, we'll have to think about that, but what do we do if we're against you on that? If we think that he hasn't, that he has gone not far enough because he has given undue weight to the ASDA proposition. Do we pick another figure? So we say instead of 8% and 4%, it's, I don't know, 10% and 6%, or 12% and 8%, and what basis have we got for doing that? And if we can't do it, what do we do?
Well, my lord, I have 2 points if you're against me on what's happening in 143. The first point is obviously that 143 was reconsidered by the judge when the error was spotted in the draft judgment. So all of this has to be understood in light of the fact that there was a subsequent reconsideration by the judge. And that subsequent reconsideration took place after he had been informed of the erroneous citation in paragraph 28. So it was a subsequent reconsideration in light of a proper appreciation of the legal principle. And the second point, my lord, is that before anything about it, you need to be satisfied that the error is in fact material. So it's not sufficient merely to point to potential misdirection of law. It needs to be shown to be material. And in this situation, it's hard to establish that any error has been material, given the nature of the exercise the judge is involved in, that it's led him to reach a view he would not otherwise have been entitled to reach.
Well, your two answers to my question are that for one or both reasons we shouldn't get to the dilemma which I put to you.
Yeah.
And you may turn out to be right about that. I don't know. I have to think about it. But if we do get there, the question remains, what do we do?
Well, in broad terms, my lord, there would be two options available to the court. One would be to send the matter back to the judge for his view on the issue. Now, on the claimant's case, that might be viewed as problematic because they're saying his judgment is already infected by some form of confirmation bias or subconscious bias. Or the second option will be for you to form a view on what the position should be on the substantive conclusion he reaches. But in this sort of context, that's likely to involve a degree of arbitrariness.
Wouldn't we have a starting point in knowing where Mr. Parker was, knowing that the judge said modest upward adjustment is needed to eliminate the possibility of under-recovery, modest effect of both factors, and where he gets to. So the scale of what he has in mind, subject to a tweak for cautious to avoid overcompensation, would suggest a rough ballpark. Is that fair?
It may provide parameters, but in that situation, there's a query as to whether the tweak is a material tweak at all.
But can I sorry, I need you to finish answering my lady, but I do want to pick you up on that point.
In relation to this, given the extent to which the judge has accepted Mr. Parker's evidence, and given the limitations on the adjustments he thinks are warranted on the substance of the questions about modelling the overcharge and what the extent to which the model might underestimate the overcharge. In my submission, the room for any upward adjustment or variation to those figures will be very limited. I mean, I accept my lady's proposition that you have some guidance based on what the judge has concluded substantively, but ultimately my submission is that even if he's made an error in 143, which I don't accept, he still reaches a conclusion that he would otherwise have been entitled to reach. It's an imprecise exercise.
That's where I want to pick you up.
My lord.
There's an analogy sprung to my mind when you were speaking about that with a case that I was involved with on valuers a little while ago. And in relation to what is usually called the bracket, within which valuers are not held to have been negligent. Even if they commit an error, if they're careless, but produce a result which is within the bracket of where valuers expressing could reasonably differ because it's an opinion. The law says actually they're not liable. Now there is an alternative view, which is that actually even within the bracket, if somebody's been negligent, because they have produced by reason of their negligence a lower figure than they would otherwise have produced, they should still be liable for the difference. And it's no answer to say, well, they still by accident arrived within the bracket. Now here you say, if I've understood your submission correctly, you say, even if the judge was wrong in his application of the ASDA rider, he still produced a number which a rational judge could have produced. It was within the range, and therefore it's not material. But can I put to you the point that actually, by reason of his error, he has produced a lesser number than he should have done? Why shouldn't the claimants be entitled to have the benefit of the correction of that error just because he's arrived still by accident within a range?
In my submission, in this case, one must not lose sight of the fact that the judge has looked at this again. So it's not a case where one has a judge who's arrived.
That's a different, with respect, that was your first point, and I'm going to come back to that as well. I'm sorry, but this is a separate point. As I understood it,
yes,
you had 2 points.
Yes.
One, the judge went back to it, and the second is it wasn't material. I'm just dealing at the moment with the second, the materiality point. Your answer to my lady on the materiality question was that the test we should be applying is, did the judge reach a view that he would not otherwise, that he wouldn't have otherwise been entitled to reach? And I think by that formulation, you're trying to say he was still within a range, a bracket of rational outcomes. Therefore, we shouldn't interfere. And I'm questioning whether that's the right approach. Because if he has made an error and has arrived at a number less than he would have arrived at without the error, why aren't the claimants entitled to have that error corrected?
In my submission, when considering appeals against factual determination, the appeal court is usually concerned with whether the factual conclusion that the judge arrived at was one which the judge was entitled to reach. Now, in this situation, it might be that the judge would, if the error had not been made, might have taken a slightly different view on the figures, but his own view after reconsideration was that he would not do so. But the role of the appellate court in this situation, when the ultimate challenge is to a substantial factual conclusion, is to look at whether the conclusion is one that the tribunal of fact will be entitled to reach. And there may be, I might take my...
Isn't it a tribunal of fact properly directing itself, if you like, taking into account the relevant factors on an evaluative decision, would have been entitled to reach?
So, my lord, yes, the tribunal, but he would still have been entitled to reach that view had he been properly directed. So if we're looking at what a tribunal of fact could have concluded, or would have been entitled to conclude, under a proper direction of law, my submission is that a tribunal of fact would have been entitled to reach the conclusion the judge in fact did, under a proper direction of law. And it might assist, and it's not absolutely on point, but there are additional passages of the Court of Appeal's judgment in Britned, where the ASDA proposition came up, which might provide some assistance in relation to this issue. So Britned is in Authorities 1, tab 11. starts at page 800 for those who are using electronic versions. Mr. Raphael showed you some passages from BritNed in relation to a first judgment that the lower court had reached, which contained some references to the ASDA proposition. There was also a second judgment that the trial judge had given in the case, which referred to the ASDA proposition in more extreme terms. You'll see from page 800 in the head notes, in the High Court, ABB was ordered to pay damages in respect to the overcharge claim, but the lost profits claim was dismissed. The judge asked B to provide an undertaking to treat the damages for the overcharge claim as if they were subject to a regulatory cap. B declined to do so. In a second judgment, B's award was reduced by 10% to avoid overcompensation. B appealed against both judgments. Now, the second judgment concerned a variation to the damages award, and the Court of Appeal addresses this issue from page 855 onwards. You'll see a heading, regulatory cap at 188. And to see what the judge had said in his second judgment in relation to this issue, I asked the court please to turn to page 858 of the bundle. And this is the Court of Appeal quoting from the second judgment of the judge below. And he's here returning to the ASDA proposition and his understanding of it. He refers to it in paragraph C as the rule described in paragraph 12.9 of the judgment. In the absence of precision in the evidence of the harm suffered by a claimant, it should err on the side of undercompensation. And you see, in the parentheses 2, to give the defendant the benefit of any doubts in the calculation. So we have there a statement where the judge is saying it's a rule. The rule involves erring on the underside of compensation. And in addition, you need to give the defendant the benefit of any doubt. And he refers to that again in D, the final part of the paragraph, the need to give ABB the benefit of any doubts in my calculation of damages generally. Now, how does the Court of Appeal deal with this problem? Its discussion begins at 199. And at 218, they reach a substantive conclusion. It begins, so the relevant passages begin with paragraph 218, page 862. Further, we consider on balance that in the absence of the undertaking, the judge was right to assess damages, taking into account the inherent uncertainties and the risk of overcompensation, and was entitled to make the deduction he did to take account of future possibilities. They then set out some concerns that they nevertheless have. We do not disguise, however, that we reach this conclusion with some hesitation and with no feeling of intellectual satisfaction. And they spell out some of the points that give them concerns. And over the page at 221 is this issue of the reference to the ASDA proposition. When in the supplementary judgment, the judge returned to where We think he should have started and he sought to assess an appropriate discount to reflect the risk of overcompensation. We think it particularly unfortunate that he should have referred to the rule of erring on the side of undercompensation, where the court is compelled to use a broad brush, and the need to give ABB the benefit of any doubt in the calculation of damages. As we have explained, there is in our view no such rule and no such need. Despite these reservations, however, we will be reluctant to remit the matter to the judge on this issue alone. Taking a broad view, we think that his ultimate conclusion was pitched at around the right level and should therefore be allowed to stand. So we have a case in which...
That's just being very pragmatic, I think, isn't it, in light of the overall importance of the point in the litigation.
It may be, my lord, but we have a situation there where there's no reconsideration by the judge. The judge has acted under a rule. The rule incorporates a principle of undercompensation and a need to give the defendants the benefit of the doubt. And in those circumstances, the Court of Appeal is still reluctant to intervene, although, of course, I accept my lord's point that the passages there indicate the court is taking a pragmatic view.
On your, I had, if allowed, I said I would like to come back to the point you've touched on a couple of times, that this was a case for reconsideration. But just before I do, were you going to address in particularly the paragraphs 226 and 246, 247, which is where Mr. Raphael did refer to, which is the
downstream pass-on point.
The downstream pass-on. Were you going to because in your list of paragraphs you included 132, which I didn't actually think Mr. Raphael referred to, but I may have been wrong on that.
Those were the overcharge paragraphs, and I was going to turn to the downstream pass-on.
Okay, well, all right, but in which case, is it convenient then, in the course of your submissions, to deal with this question of the reliance which we can place on reconsideration now, or do you want me to do it later?
I can do it. I can
Right.
try and address
Okay.
my lord now.
So, as I understand it, there are 2 points about the reconsideration. The first is that it was already infected by confirmation bias, given the timing of the judge had to deal with it and everything like that. And that's not in any way to say the judge wasn't doing his level best to deal with the point. It's just that confirmation bias is a thing. The second thing was something that came up in the exchange, which you get from paragraph 254. And this is really that the judge, I put it to Mr. Raphael, and I'd be interested to see what your reaction to it is, because it's really a point for you, I think. In paragraph 254 of the judgment, turn it up. Page 138. Page 138. You'll see that the relevant bit is appears in the first 5 lines. So let me just read that. And my understanding is that the correction that the judge made to this paragraph, when the point was put, the paragraph 28 point was put to it, was actually to add the words in order to avoid overcompensation. See the authorities referred to paragraph 28 above. Or certainly added the words in order to avoid overcompensation.
That's not correct, my lord. So
is that not right?
What happened was that the draft judgment contained the words in order, but the sentence then just had the dash going to see authority, so it was an incomplete sentence. But the words "to avoid overcompensation" were the ones that were added. So it was an incomplete sentence, and that's
but if anything, the judge should have been. The judge should have taken out the words "in order," because if he'd have stopped the sentence that a court should err on the side of caution, it would have been very difficult to say that that wasn't in accordance with the law, because it doesn't contain the ASDA rider. But he actually added the words to avoid overcompensation.
Well, it may be that he added the words which he had always intended to be there because it was an incomplete sentence and he was simply correcting a typographical error, and that he felt he had dealt with the substance of the point by his footnote. And that's how I understood what we were told, but who knows?
Indeed, my lord.
So my question was really, how much reliance can we place on the exercise the judge went through when, at least on the face of it, this seems not perhaps to be a full treatment. In fact, the judge should really have been reversing out of that error, not adding to it.
Well, in my submission, there are a few points. First, in terms of practically how the judge dealt with the matter, he was provided with the note which identified the error. He then had a choice about what he should do. Now, does he go through the judgment and delete all of the references that were to the paragraph 28 principle and to any other objectionable passages in the judgment in order to protect himself in the public version of his judgment? Or does he take the view that instead, I'm just going to be transparent about this, I'm going to include a footnote, I'm going to undergo the substantive reconsideration of the issues and just be clear about what the judgment stated in its original form? That's the second course the judge has adopted. It is a proper course in my submission. And the first course would have also given rise to complaints. He found himself in a position, my lord, where there was a real limit on what he could do. So it's a draft embargo judgment that's provided to him. And I make these points when you're considering the risk of subconscious bias or confirmation bias. A fair-minded and informed observer would take into account, firstly, the possibility that the strong likelihood or the fact that all judges are prepared to change their minds when points are drawn to their attention. Secondly, the relevant findings to which objection was taken were contained in a draft embargo judgment. So this isn't a commitment of position in a public judgment that's already been issued. It was only the representatives and the parties who knew about this. And draft judgments are, of course, subject to change until they are final. And the judge, thirdly, nevertheless chose to be transparent by retaining his original language, acknowledging his error, but including a footnote that sought to address it. Now, I ask practically, what is the judge supposed to do in this situation? I mean, if it's being said that the reconsideration would inevitably be affected by subconscious or confirmation bias, is he supposed to, in that situation, not deal with the case any further? He's made a commitment of position in a draft embargo judgment, and he's not to issue final findings because of the risk of confirmation or subconscious bias. I think here, the issue really is that the risk of some subconscious or confirmation bias is just being assumed from the fact that he didn't change his substantive conclusions. Whereas the relevant question in my submission is whether, as a result of what he stated in his draft judgment, there was a significant risk of subconscious or confirmation bias. And the reality is it was just a draft judgment that was provided to the representatives. There's no public commitment of position. The judge was making amendments to his judgment in light of points that parties were raising about contents of his judgment. And he's just chosen to be transparent here and fair. It is unfortunate, I don't disguise that fact, it is unfortunate that things transpired the way they did. But in my submission, it will be wrong in this situation to conclude that there's an unacceptable risk of subconscious or confirmation bias arising from the judge's reconsideration.
Is there anything you want on this question?
On that point.
I had one or two questions. One is simply a practical point. I think Mr. Raphael said to us that if we were to adjust any of the figures, so for example, if we were to say it's not 8% but some other figure, whatever it may be, there would be no difficulty for the parties working out the financial consequences of that. Are you equally confident?
My Lord, experience cautions against confidence on quantum because we spent about a year fighting over quantum. But he is right that there is a spreadsheet that can perform the mechanics of quantum calculations.
Another point I was going to mention, which is probably more related to downstream pass-on, as well as potentially an independent point in its own right. We haven't looked very much at the section of the judgment which deals with the loss of profits on sales lost. And Mr. Raphael says, well, if he wins on downstream pass-on, then we wouldn't need to go there. Obviously, if he doesn't win on downstream pass-on, then that part of the judgment would stand. But that section itself contains quite a lot of references to the Section 28 broad brush approach, including what might be viewed as using the ASDA proposition. For example, paragraphs 254, 255 and 264. Now, two questions, it seems to me, arise out of that. One is, do those paragraphs, if indeed they do represent applying the ASDA proposition, shed light on what the judge was also doing in the paragraphs we're focusing on, paragraph 143 at the moment. And the other is, what do we do about those paragraphs, if anything, if you are right on downstream pass-on, which you're about to tell us that you are, so that the lost sales judgment stands? Perhaps you could think about that.
Yes, my lord. So in relation to the relationship between downstream pass-on and the loss of sales claim, if downstream pass-on is assessed at 0, so if you were with Raphael on that point, then the loss of sales claim element would disappear because nothing has been passed
and therefore we don't have to worry about any
worry.
errors which in its formulation which may be contained in the judgment.
In relation to, if you take the view that downstream pass-on was established, but there is some other level at which downstream pass-on should be assessed, that would feed into the lost profits claim, even if you weren't to address any errors in the lost profits claim itself. In terms of the lost profits claim,
Just pausing there. So if we were to say not 65%, but some other percentage, that would affect the quantum of the lost profits claim.
it would, my lord.
In a way which we would have to hope you'd be able to work out, I suppose.
Because
We certainly don't have the material to do that.
No, indeed, my lord. The lost profits claim is parasitic upon downstream pass-on being established. So
Yes.
it's once you've shown that prices have been increased, that the loss of profits on those sales arises.
Yes, I understand that.
My lord. In relation to potential errors in the substance of the judgment relating to loss of profits, my lord, I say, my lord put to me whether the passages in relation to lost profits inform the question of what the judge meant, for example, at 143.
Yes.
On 143, my submission is that it's clear on its face what he's doing there, because he refers to eliminating the possibility of under-recovery. So whatever he may have said, or unfortunate choices of language in other parts of the judgment, don't provide a sufficient basis to go behind the express words he's used there in my submission. He's eliminating the possibility of under-recovery. That would be to assume against the judge on the basis of language he's used elsewhere in the judgment. And in terms of any use of language in the section dealing with lost profits itself, which are considered to be incorrect, there would again need to be an assessment of whether they have actually affected the judge's conclusion on lost profits. My recollection is that the issues that were actually in dispute before the judge on lost profits were relatively narrow, so he decides disputes on certain of the inputs into the lost profits claim. So they're indicated by the subheadings in the section of the judgment: elasticity of demand, the diversion ratio, and extended warranty margins. And it would be necessary to consider what the effect of his statements is in relation to those passages of the judgment. We haven't gone through the exercise because the focus has been on downstream pass-on and overcharge, and those findings being impugned on the basis of the ASDA proposition. We've not gone through the exercise of following up every reference to a potential principle of.
Well, the last thing I want to do is open up a whole new area of the case, that's for sure.
But the appeal itself, if one looks at ground one of the appeal, one sees that there's an objection taken to the use of the ASDA principle and a problem of subconscious bias. And it's stated that that's affected the consideration of downstream pass-on and overcharge, the errors that arise under grounds 2 and 3 on the claimant's case. So the focus has been on the error affecting those aspects of the analysis, which are the most significant aspects of the analysis when it comes to quantum. I mean, those are the main issues that the judge needed to decide. But that separate exercise, my lord, would have to be performed if your lordships wanted to fully inform beyond the implications of addressing those points.
All right, well, does that take you to ground one as it affects downstream pass?
It does, my lord. So in relation to downstream pass-on, the particular paragraphs that I understood the claimants to rely upon were 226, 246, and 247. On 226, which is at page 129 of the bundle. So the judge starts the paragraph referring to the nature of the evidence relevant to downstream pass-on. And he says that the approach summarised in paragraph 28 is the one I must apply in the circumstances of the case. Had this claim involved companies currently traded, I would have expected much more relevant material to have been available, supported by all evidence. As is apparent from what I have said, there is no such evidence. So the observation that's made there in respect of the approach summarised in paragraph 28 is just an acknowledgement that the judge is operating in a situation where evidence is limited and that he's going to have to apply the broad axe. There's no direct connection here.
You can go further, can't you? Can't you just say that everybody acknowledges that the Broad Act operates where there is uncertainty, and uncertainty is the product of the lack of evidence.
Indeed, my lord. But the point here is this is just a reference that's made in the context of that uncertainty, including by reference to the lack of evidence. On 246, now I acknowledge that in the sentence at the bottom of page 136, paragraph 246, there is an express reference to erring on the side of undercompensation where there is uncertainty, in order to avoid the claimant recovering more by way of damages than it will be entitled to applying conventional principles. And I acknowledge that that is an unfortunate reference. But in my submission, 246 should be read together with 247, which follows. The judge introduces 247 by referring to the narrowing of the range of uncertainty. So he's got to between 50 and 100% in that context. And then he applies the principle summarised in paragraph 28 above. But what he balances is the need to ensure the claimants are properly compensated. So he's accepting that the claimant should be properly compensated against the requirement to exercise caution where there is uncertainty. So in my submission, the judge still has in mind, in paragraph 247, the need to ensure that the claimants are properly compensated. And that the earlier statement in 246 should be read in that context. 247 is where the principles are actually being applied. And he reaches a view that there should therefore be a blended rate of 65%. Of course, my lord, my lady, I make the same points in relation to these passages which relate to downstream pass on as I did on the overcharge, which are being reconsidered. You have my submissions on reconsideration, and that the court would, in my submission, wish to be satisfied of the materiality of an error before setting aside a substantive conclusion that the judge drew. My lord, my lady, may I just take instructions? There's one point that I'm asked to raise. My Lord Justice Mayall's, or the court referred to questions about the nature of the adjustment that might be made to, for example, the overcharge if you were against us on our submissions in the case. And we'd asked the court to consider the extent and implication of the increase. So if you were to increase 4% to 6% or 4% to 8%, that is it's a doubling of the judge's finding, as it were, going from 4 to 8. So we'd ask the court to bear in mind that the finding is on a percentage basis that's taking place, in order to ensure that an adjustment that's made, a modest adjustment that's made, is truly modest, if one is thought to be necessary. I'm just asked to raise that point by those behind me, my lord. Unless I can be of further assistance, there's only one point I need to come back to.
Well, one point which you may or may not be able to help on, and that is the judge's eventual choice of pass on, having identified a range of 50 to 100, between 50 and 100%, was 65%. What, if anything, does that tell us about his thinking? I.e., why can we discern, or can you suggest he went for that figure rather than, say, the midpoint, which might have been a choice that the judge would think about, or indeed anything else? Can you shed any light on that?
I can try to, my lord. It would involve some speculation on my part. So in relation to downstream pass-on, obviously the higher the percentage figure for downstream pass-on, the lower the amount of the overcharge that the claimants are able to claim directly, although it has an effect on the loss of profits.
Yes.
So the judge here, having decided to come to the view that the relevant range on the evidence is between 50 and 100, has actually taken a conservative approach by deciding to go for 65 rather than a midpoint estimate. But his judgment doesn't set out...
Conservative in the sense of more favourable to the claimants than the midpoint.
Indeed, my lord.
Yes.
The judgment doesn't set out a scientific method for coming to that percentage figure, because we're necessarily here in the realm of the broad axe, where a scientific method isn't available to the judge in coming to a view on a particular percentage. But he has, in my submission, reached a view on downstream pass-on, finding a blended rate of 65%, which of itself is not disclosing an error in the nature of erring on the side of undercompensation. As my lord points out, if you had got to the point, as a judge, if you get to the point where you think, well, the relevant range is between 50 and 100, and you want to be completely neutral about it, you could opt for the midpoint at 75%. He's decided not to do that and to go lower, my lord. But I am here engaging in speculation.
Isn't the point I think my lord's putting to you is that if he'd made the mistake of erring on the side of undercompensation, he would have chosen something between 75 and 100. So what can we assume from the fact that he went lower than 75?
Well, I'd invite you to assume that he has not made that mistake.
Isn't that the point that's being put?
Well, it may be, that's one interpretation, and of course we're all speculating here, I suppose, but another is that although he says between 50 and 100, if he's giving any weight at all to Mr. Raphael's factors about psychological pricing and extended warranties and all the rest of it, a figure north of 90% actually looks pretty unrealistic. So maybe the real range was not between 50 and 100, despite what he said, but was more like between 50 and some other figure. I don't know. As I said, it's all speculation, but I was just inviting any clarification or insight you might have in view of the way in which it was argued before. Well, I mean, was, for example, the figure of 65% something that first emerged fully formed in the judgment, or had there been discussion in submissions about what figure might be adopted given various permutations?
So the figure, to my recollection, the figure of 65% wasn't a position adopted by either party. The parties were far apart on the downstream pass-on issue. The claimants were obviously arguing for 0. My clients were arguing for almost full pass-on or almost full pass-on. The figure of 65% is not one that was ventilated as an argument. It's the judge's assessment based on the evidence as a whole, going through the process he sets out in this section of his judgment, my lord.
Yes. All right. Thank you very much.
There's just one point, my lord, that I needed to address you on. You asked yesterday a question about disclosure of long-term supply apply
yes.
contract. Yes, so my instructions are under a consent order of the 19th of October 2022. Provision was made for sales contracts with my client's top 10 LCD panel customers to be disclosed, and on the 1st of December 2022, those were disclosed. The documents falling within that category were disclosed to the claimants.
Right. Was there any evidence at the trial, as distinct from disclosure documents, about whether they included fixed prices?
No, my understanding is those documents were not included in the trial bundle and were not addressed at the trial.
Right. Okay, thank you very much. Yes, Mr. Raphael.
My Lords, my lady, I'll touch on that matter myself first as well. When I was addressing you on Monday, I said there had been no disclosure of long-term contracts. That was an error on my part. I was misinformed. I apologise for that. What happened is then, yesterday your Lordship raised the question, and we've gone and done some investigation. And we found out, yes, there had been a request that had been forgotten. I don't know the exact details of what happened, but it had been missed in some way or other. They have gone and investigated the disclosure. The documents in the disclosure have never been considered. I'm not going to tell you exactly who read what when, but they've never been properly considered, let's put it that way for sure. And I think probably never been read. They have been considered overnight. I don't wish to give evidence.
Well, I don't really want to know what's in them if they were not evidence before the judge. I wanted to know whether they had featured in the trial.
No.
And the answer is that some documents were requested and disclosed, but for whatever reason, whether because nobody ever read them or they didn't think they were very interesting, they were not part of the trial.
I'm not going to give evidence on my feet to what they contain. What I am going to say is that we are giving active consideration to a Ladden Marshall application. Obviously that has certain constraints on it, which we will consider, but we're giving active consideration to that point. That's
All right, well, the hearing is going to end in about 20 minutes, so we'll see what happens in those 20 minutes.
we won't be able to make the application today because it would require, for example, explaining how errors were made and so on and so forth, and so that wouldn't be possible. The court may, when it gets the application, take a certain view on it. But may I say this? There was...
Well, I mean, saying that errors were made is not perhaps the best starting point for a Ladden Marshall application, given that
Indeed.
one of the questions is whether with reasonable diligence documents could have been obtained.
Indeed, that's quite right. I accept that, that's why we're considering it. But may I just mention, without remotely arguing the application, another point, which is that there are various submissions made below and before you by the respondents to the effect that there was no evidence of long-term contracting. My learned friends may wish to consider, given what documents they have and they know about, whether those submissions are ones they wish to persist with, and the fact that those kinds of submissions were made at the trial, when I'm not testifying to what knowledge people on their side had, that's obviously a matter for another moment, but given that they made submissions of those kinds, and it may be that there was some knowledge of the documents in question, that might be a factor that could play in a Ladden Marshall application. I don't want to go too high on what that suggests. I'm just simply saying that's the kind of things that we'll be factoring into our Ladden Marshall application if we make them.
I'm sure you would consider very carefully
We would.
indeed before making any such.
We would make that is precisely why I put it as cautiously as I have today. I'm not making any assertions of anything at this stage.
Just to be clear, I've not seen documents that he's talking about. Not considered them. They weren't in the trial bundle.
Yes.
I didn't have any knowledge of it.
Bearing in mind it's likely that those who had speaking roles or indeed sitting in court roles at the time of trial may well never have seen the documents because they didn't make it into the bundles.
No, as the barrister team on our side, I can say for sure I have no knowledge of any of this, and I have no doubt that's true for Mr. Mooser as well. But it's a question that would have to be carefully considered, and that's why I don't want to rush into anything.
Well, the position is that there was, in fact, no evidence elements of long-term contracts, although both parties had access to evidence which, for whatever reason, was not deployed. Anyway, if you make that application, we'll deal with it. It doesn't, at the moment, sound a very promising one, but we'll see if it emerges.
Indeed. That's all I wanted to say on that point. And I'm not seeking remotely to give evidence as to what these documents relate to. But I would like to apologise for the error I made to the court on Monday. That was made in lack of appreciation of the disclosure.
That's very candid, thank you.
Lords, then I will, in contrast to Mr. Musa, go in the order of my grounds of appeal. So I will start with the ASDA proposition. Now, you're all fairly familiar now with these relevant paragraphs. You've obviously actually considered them, and obviously creates a genuine issue which you need to confront because of various dimensions. Because if you're with me on, is there a problem, it creates a problem for the court as to how to respond. And also, dealing with a respected judge like this is a serious matter which one takes very cautiously. So, I'm not going to go through every line, every paragraph, because that's not what this is about, we would say. That parsing a particular paragraph by saying if you read that paragraph on its own is just about a range of uncertainty. We say that's not the right approach here. For two reasons. The first reason is, whenever the judge says, I'm dealing with a range of uncertainty, he's doing two things in that range of uncertainty every time. He's doing broad acts, but broad acts constrained by ASDA. So simply focusing on the wording of a paragraph to say, well, that paragraph's innocent on its own, it isn't the answer. He has, and that would be so even without the constant references back to the principles in paragraph 28. But as the question by my Lord Justice Mayles made this point, he does do that again and again and again. And principles means two principles. Likewise, when he refers to the cautionary principle, that is plainly ASDA. So it's not just that he's always referring to a pair of principles. He often is referring specifically to the cautionary principle, and we know that the cautionary principle is ASDA from the footnote, which says it. Likewise, 256 is absolutely clear that what he's dealing with throughout is a pair of principles, one balancing against each other. And likewise, the question from my Lord Justice Snowden, 143, when you work it through closely, there are two principles each time. He goes a bit, and then he pulls himself back. So we have eliminate possible under recovery, but limited, so as to take account of what I consider likely the modus effect of both factors, and the need to be cautious to avoid overcompensation. And again, it's not a matter of parsing particular words, it's a matter of how he was approaching the whole judgment from the beginning because of ASDA. And so our submission to you, it's a short one, you've got my submissions in detail before, but now being brief, you have going throughout this judgment a pair of principles at war with each other. One, a general approach to uncertainty, the other, a constraining principle. And that was wrong.
Okay, but the use of the expression caution, I think you said a few moments ago, you thought that was of itself indicative of some error.
Yes. No, well,
But I just question that because I thought from reading Britned that caution arising from the fact that you are making estimates in the absence of precise evidence is legitimate, is appropriate. But what is inappropriate is to err on the side of caution to avoid overcompensation.
may I parse that into two separate bits? Firstly, this judgment and the genuine point. So in terms of this judgment, I think there's two bits of wording to distinguish. I'm now playing wording games, but I shouldn't really. So there's caution and the cautionary principle. Now, I think you have to give those different emphasis, because it is plain that the cautionary principle is ASDA. He says that in the footnote. So you might, if you were against me on my general point, think that the word caution on its own is less infected. I would say to you, well, actually put them together. But it's clear we say that, yes.
I'm sorry.
I'm sorry,
No, I cut across you. You finish, sorry.
I'm very grateful. It's plain that at least when he says the cautionary principle, that's a very clear reference to ASDA. And we would say in terms of when he's using caution, his concept of caution is the two principles. It's influenced by.
So how does that, for example, fit with the end of 247 of the judgment, which is about the blended rate, the pass-on?
Well, that's my...
I mean, he specifically there says a requirement to exercise caution where there is uncertainty. I mean, that's pretty clear, isn't it?
On its own, correct. But in the paragraph before, he's got two principles at war with each other.
Yes.
And again, let's take the example, the helpful example you gave me of a valuer. If a valuer had made this kind of error in one paragraph of the introduction to his valuation, and then the second paragraph doesn't look quite so bad, that's exactly the kind of case where a court might set it aside. So we say that that particular point on 247 is an example of pulling this out of the psychological reality of what has really happened here. It's not about worthing parsing, it's looking at the reality of 28, which he never reversed out of in any way. So that's my submission on the wording. I mean, you just simply have to ask yourself, this is all, of course, very unfortunate, but the reality, the actual reality, do you really think a judge who's articulated the judgment from the way up, from the beginning in this way, with so many references back to ASDA, with so many points where there's the warring principles occurring quite clearly, has put himself in a position where he's immunized from the risk of error by particular bits of wording in certain paragraphs? The answer is no. The answer is no. Plus, those wordings actually aren't as clear as you would like, because while he says the requirement to exercise caution for 247, he's got before that applying the principles in paragraph 28 above, and that is the principles. And to the extent I need more assistance on this, even when we get to the footnote, he's actually not capable of fully rowing back the errors we've seen. Well, but that's on the wording. Then we come to, is the error material? And this question of, is it okay if you end up in a range that another reasonable judge might have got to anyway? I'll take which is a very helpful clarification. I'll take that first, if I may. So that point, we say, it's a misconception of what the test for appeals is about. The test for appeals is about when appeal courts should interfere. That's a question of pragmatic management of the court system as much as anything else. And so that is why an appeal court doesn't interfere when a reasonable judge could have reached the same result. It doesn't mean that the judge at first instance can be anything other than right. He has to get it right. He has to reach the right judgment. And so if he has made a clear error of approach which influences everything else, and if that clear error is material, it is simply no answer to say another reasonable judge might reach the same result. Because that is actually saying the judge can be wrong. It would also lead to grossly unfair results in many situations. You would never apply, you never dream of applying the same kind of concept to bias, for example. Apparent bias here, but well, actually a reasonable judge could reach the same result. That's not how we would do it. So that point is a misconception. So then we need to get to, is this material? Can you infer that the error is a material one? Now, there would be cases where you could do something like the ASDA error, and it was clear that no error would affect anything. Whether because the decisions are so binary that ASDA isn't going to play in a meaningful way, or whether because even if it's a qualitative, broad assessment, it's so obvious that that's what it's going to be. That's the BritNet situation. You were never going to get to anything different to that. That from the facts of the kind of assessment you were engaged with, you can say, well, that's not going to be material. I accept that possibility. But is this that kind of case? And we submit to you, no. I have to divide my submissions there. Obviously, I'm strongest on 2 points. I'm strongest on the upwards adjustment, and then on downstream pass-on. It's a higher hill for me to climb on the broader assessments. But on the upwards adjustment in 143, we submit the proposition that that's not materially affected is unsound. Firstly, because, and it was my Lord's helpful intervention, focusing on how there's a two-step process going on within that very paragraph. That's clear when he does the first approach, but then he limits it. So there you see something material is going on. And secondly, the kind of assessment we're dealing with. He's making a very small upwards increment of 2.3% and 1.6% to on the basis of two quite free-form concepts. How much adjustment should be made to affect the risk that there was an error in the model because the post-cartel data was influenced by the cartel. And secondly, endogeneity. Two quite free-form assessments in a situation where it is easy to see how a much bigger adjustment could have been made. I've given you the point. The non-endogenous models were significantly higher. They were 14 to 17%. So in that context, we say it's easy to see, and it is the correct answer, that the error was material there. Standing back, and this is our more general point, what is going on here, you see it particularly from paragraph 140, the judge is anchored to Mr. Parker's judgment, psychologically anchored to it, driven by ASDA to be so anchored. That naturally influences the degree of percentage increase he is willing to make.
But if you don't succeed on grounds 2 and 3, then, in a sense, he was right to be anchored to the Parker model. It's very difficult to be able to say, well, he got everything else right, but he, for some reason, shouldn't have been anchored. You know, there's no specific criticism of where he got to on Parker. It's very difficult to say, well, he shouldn't in some way have been anchored to it, so he's a sort of free-floating judge.
That's an interesting point, my Lord. Reflecting on it, though, I think I can push back in this way. If we've failed on overcharge, then you'll have certain variables being the correct one. The price lags will be excluded. That's what we'll have failed on. We will have failed on a more general robustness approach. That's what we will have failed on. I don't think that completely dispels my anchoring point for this paragraph, 143. I think he is still anchored to it for the purposes of Parker's model, for the purposes of dispelling uncertainty and erring on the side of undercompensation. That's how I put that. I think it's an error to say that if we have not logically displaced his assessments on price lags and robustness, that he's still not doing anything influenced by ASDA, which is changing where he's going on 143. Maybe the anchoring point falls away, but it remains the case.
That was my point. I mean, I well understand you might say, if you fail on, it's ground 2, in fact, for 143, isn't it? Yeah. It's got nothing to do with downstream pass-on. It's ground 2, so you fail on ground 2. Yeah. So he's got the Parker baseline model. He says, I need an upwards adjustment to Parker. I fully understand you say, well, the ASDA should mean that he should have done more to uplift Parker, but I find it difficult to understand why we cut him free from Parker at the start.
I'll come on to that briefly. And the answer we say is this, that, and this is obviously a more difficult point for the court, I appreciate that. There are a range of assessments here, including not just on price persistence, but also on how to treat the endogeneity variable itself. And it's possible, actually, thinking about it now, that what this really is showing is how ASDA interplays with ground 2C. That may be the answer. Probably perhaps the way to conceive of it is that one of the roles of ASDA is influencing him against the wider approach to alternative models that ground 2C invites. That may be the best way to put that. On to downstream pass on. Oh, and a final point before I move on from that issue. My Lady Justice Cockerill referred to modest in 143, but we would say modest in itself, influenced by ASDA from the start. Now, as to Britned in the supplemental judgment, if we pick up the bundle of authorities, at volume 2, the physical, tab 11, and we're looking at page 858. Just to note that in Britned, Mr. Musa, I think, took you to C. I can't recall if he read D to you, but you see in D following, there is an immediate correction. I've been using a broad brush and I've sought to ensure that Britned is fully compensated according to law, but not overcompensated. That's a much stronger counterbalancing. It's actually a very strong counterbalancing of the sort one doesn't see it in the judge's judgment, certainly not his initial judgment, and even not in his footnote. So the Britned concern was very much less. That's the first point I'll make on Britned. The second point to make on Britned is what comes out of 222, and I think this already fell from court in an intervention. It's plain this is a pragmatic, cost-driven decision. This is a minor twiddle in a major judgment. And this is page 863, paragraph 222. Despite these reservations, however, we'd be reluctant to admit the matter to the judge on this issue alone. That's crucial to what they're saying. And then the second point they make is, this is one of those cases where whatever happened, you'd be at 10%. That's, I think, an explanation of what's going on there. So I don't think that case is materially against the propositions we're putting to you. That then takes you to, well, what I'll take next, what should the judge have done, and then what should you do? In terms of what should the judge have done, it's correct that simply scrubbing out the references to ASDA in the public judgment would have had unsatisfactory features. And indeed, in many ways, it's commendable that he didn't do it. But Mr. Musa gave you a false pair of options. He said, well, basically that was his only option. But there was another option open. It was not a pleasant one for a judge, but it was to actually go back and properly re-examine, rethink each assessment, take time to do it, engage in a process of re-engaging with the evidence and the submissions. And that was obviously unattractive, but it was open. So that's as the judge. Then as to what you should do. Now, a remission is unattractive to everyone here. That's partly because this case already cost more than the damages sum awarded by the judge. It will also be psychologically impossible for the judge. I respect this. In the unusual circumstance of this case, I think that would be an unfair. Submit that would be an unfair thing to ask them to do. So remission is not, I think it's common ground, an option that we're commending to you. So what then to do? Now, in relation to the paragraph 143 issue, we've given you parameters in our supplemental skeleton, and I mentioned them in opening. It may be helpful just to look at that again. That's in the core bundle, tab 15. At paragraph 32, it's on page 328 of the bundle. And in relation to the specific 143 adjustment, what we've suggested is that models, because of course one thing he was adjusting to deal with was the risk of endogeneity. And models which were not his preferred models, because he thought that GDP growth was a bit more distant as an indicator than semiconductor billings, but nevertheless were there as models, gave figures of 14% plus, and you've seen that in the aide-memoire. And we'd say that if he'd been taking a neutral stance, he would have moved further towards those as an indication, and that also gives you a yardstick with which to assess the adjustment. Now, that's not saying that you go straight up to that adjustment. There's obviously considerations you'll be bearing in mind as to midpoints and so on and so forth. But that gives you a yardstick for your adjustment, how far you should move towards 14%.
Right. We better adjourn now. How long do you think you'll need to finish?
I've had about 20 minutes just now, and I propose to stick strictly to my intended reply time of an hour and a half. So that would be an hour and 10 after lunch.
Right. Very good. Well, we'll resume at 2:05.
Court arrival for April.